government
Good morning, everyone.
have said that
we'll start in a few minutes because, as you know,
are going to the
this is live
Privy
from
Council,
10 o'clock.
and we are saying you ought not to do it without finding out whether the people want it or not by way of referendum.
All right, so the Privy Council, it should be a final court of justice, or what about
until the people have confidence in the CCJ. That's all, basically.
Okay, as a former Prime Minister, how do you think this government has performed, and how do you think that they are going to come out from this general election this year?
The fact that the majority of people in the country, 30% I think, don't know who to vote for, answers that question for me.
Okay, you answer my question. How do you think Kamala Prasad
I think they have made a lot of mistakes. I think they didn't have a plan. They didn't know where to go. I think there's been enormous waste, corruption, and mismanagement. Enormous. During their office, they have spent 400 million. Dollars. No, 50. I forgot. Yeah, billion dollars. And I believe, with that kind of money, everybody in Trinidad would have been housed, would have had water, would have had the basic necessities. That's my feeling. But the money is gone, and the people are still without water, still without house, still without roads.
Do you think that the giving out of houses at this time, do you think is a political gimmick?
Of course it is. Why weren't they given out before? Yeah. So it means that they will look and see people homeless, but wait for a political opportunity to give them homes. That's terrible.
All right, so it just remains to be seen what is going to happen.
Of course.
Thank you very much, sir.
If you ask me who am I voting for, I can tell you right now.
Me?
Yeah, none of the above.
Why you all have me out here on a Sunday morning? Yeah, you can tell me. I need to sleep, you know.
This is voted.
Okay, you think so? All right. What is your opinion on the CCJ being the last court of justice instead of the Privy Council?
I am totally against it unless the public people say so. I believe in history has shown that many times decisions which are made in the local courts are overturned by the Privy Council. Critical ones, whether it's malicious damage, whether civil proceedings, whether for murder. And therefore we will be foolish to travel to the council when we have seen from the history of this country. You have to have the referendum, but even then you have to educate the public on what they of course voting for. Because many people come and say, what are you coming here for? Well, can I send me? What are you coming here for? Can I say to come? They don't even know what they're voting for. So you have to educate them first before you decide to be council. But for me, I'm very, very, very reluctant to do that.
All right. How has this last government performed? I mean, you were part of the government.
For this government, I want to say one thing. That honesty must be the best kept secret for this government. Because if anyone, I've never seen a government as corrupt as this one, as arrogant, as mismanaged the patrimony of this country. And therefore, for me, on all those counts, this government has failed us. When we came, the ideals which we came into government with were all dissipated. And what we saw is a greed that is unparalleled. And not only a greed unparalleled, but though many times sanctioned by the Prime Minister. And this for me is unpardonable.
Okay.
If I have my way, I will ensure that they'll do it a second term. And more importantly, that many of those who commit crimes should pay for the crimes they have committed. Because this is robbing the state, robbing the children, robbing your future. And it's no secret. All their big contractor friends, they're giving away the state lands to their finances and their friends and family. This is wrong. This is not what we struggle for. When I look to move Mr. Pandey from office, to put Mrs. Prasad, he says, never mind why this life, my dream, never.
Good morning.
I completely sponsor
the Court of Justice as the final court of appeal for Trinidad and Tobago without a vote by the people on a referendum called for that purpose. you are going to hear today from...
I also welcome, no stranger to you, a distinguished former Prime Minister of Trinidad and Tobago, Mr. Basti Pandey. And one of our hard-working members of Parliament, Mr. Jack Warner, the Member of Parliament for Chaguanas West and leader of the ILP. Mr. Nizam Mohammed, who is a former Speaker of the House of Representatives and also no stranger to Trinidad and Tobago. A young lady who is an attorney at law and a former member of Parliament and who Trinidad and Tobago is looking for a lot in the future, Ms. Michaela Pandey. We are expecting Mr. David Abdullah, the leader of the MSJ. I suppose he will come during the morning period. And he's here? Where is he? Oh, Mr. David Abdullah. Just to put your mind at ease, or to disappoint you, it is not a political party. We are gathered here today in order to discuss a very serious issue, and it's important to have persons from all walks of life to discuss that issue. And if I may continue the welcome, you will hear from Mr. Denzel Johnson, who is a legal officer of Democracy Watch, and Ms. Amina Rowland, who is also an officer of Democracy Watch. Democracy Watch is... And Mr. Denzel Johnson, right, great. Now, what we are going to do, we are going to have talks for 2 hours from the platform, and then we are going to give you a half-an-hour opportunity to ask questions. If I may announce to you, I'll be the chairman of the proceedings today. I will say a few words of welcome and also give my views on the matter. And if you need a washroom, they're on the side of the building. Production part. I want to focus that what we are dealing with is an issue which affects the lives of every individual. Because directly or indirectly, either you or your relative or your friend would at one day have to access the court systems of Trinidad and Tobago. And the present law is, and this has been for centuries, that if anyone has a case which falls within the particular category, civil or criminal, that whatever the High Court in Trinidad and Tobago decide, whatever the magistrate decide, whatever the Court of Appeal decide, the individual knew, or the group knew, that they can access the final appeal to the Privy Council in London. Now that has been for centuries. Now this discussion today is no reflection on either the competence of the courts in Trinidad and Tobago or the competence of the High Court, magistrates or Court of Appeal. This discussion today is that if the government or the opposition want to remove the Privy Council and replace it with the Caribbean Court of Justice, the people of Trinidad and Tobago must have a say on that issue. And the say must be not only consultation, but they must be able to vote on the issue in a referendum call for that purpose. And what we are going to show you today from the discussions, you would see why that is important. Because at the present time, the Caribbean Court of Justice, there is no appeals from the Privy Council, from the Caribbean Court of Justice to the Privy Council in London. So there is no basis for the population of Trinidad and Tobago assessing for themselves. And this is not only for the legal profession to assess, the judgments that come from the Caribbean Court of Justice. And what we are saying is that all the studies have shown that public confidence in the administration of justice is essential for democracy. Because if people do not have confidence in the courts and in the final court, you can have problems for democracy in Trinidad and Tobago. So if you have to have the Caribbean Court of Justice now in Trinidad and Tobago, the judges, the pool of judges, would come from the present courts of appeal of the Caribbean region. And what I want to do today is to share with you some of the experiences I had as a lawyer and as a citizen in respect of the Privy Council and the court system in Trinidad and Tobago. I don't think it is understood that when an individual feels the pang of injustice, what deep-seated feelings there are. As a young lawyer, for example, in 1975, I saw my clients facing injustice from a judge. And I decided to protest that injustice. So I told the judge that what he was doing was unjudicial, that he was guilty of unjudicial conduct. The judge jailed me for contempt of court for 7 days, simple imprisonment. I was asked to apologize. I refused to apologize because I said if I go back before the judge, instead of asking for 7 days, I'll ask for 21 days. Because I felt what I was doing was right. And I had confidence that what I was doing would be held by the courts of Trinidad and Tobago to be right. So I went to the court. I had to serve the 7 days simple imprisonment. I went to the court, and the courts of Trinidad and Tobago, the High Court and the Court of Appeal, held that whatever a judge did, even if he violated the Constitution of Trinidad and Tobago, the courts could not grant relief. In other words, the courts of Trinidad and Tobago decided that the judges were above the Constitution in the execution of their judicial duties. I had to go to the Privy Council. At that time, when I had to make a decision whether to go to jail for justice or to apologize, I had 3 young children, babies. One had just been born. And so you could imagine the trauma that existed in my family. And I saw and I felt the pangs of injustice in that my court in Trinidad and Tobago told me that whatever a judge did, even if he was wrong, I had no redress. So I went to London, and it's now a matter of record. In the law reports of the Commonwealth, Maharaj and the Attorney General, number 1, which set aside the conviction, Maharaj number 2, which gave me damages and reversed the Court of Appeal. Now, as a lawyer, I have been involved in many cases, not only from Trinidad and Tobago, but from the Caribbean. And we have on the platform here today Sir James Mitchell. He was Prime Minister of the St. Vincent and the Grenadines for several years, and he will tell you more about it. When he lost, he didn't lose office. When he gave up the Prime Ministership, and there was a new government in St. Vincent, the Prime Minister of St. Vincent decided to have a commission of inquiry. But the mission of the Prime Minister of St. Vincent was to jail Mitchell. Jail Mitchell, used the Commission of Inquiry to jail Mitchell. He set up the Commission of Inquiry into a project. The Commissioner of Inquiry was a former Judge of Appeal of the Eastern Caribbean states. And what happened? I wrote to that judge and I told him that if you want my client, Sir James, to come before you to answer questions, tell me what the allegations are. Give me the particulars. No reply. The commissioner proceeded to take evidence in his absence and then wrote a secret report to the Director of Public Prosecution, unknowing to him, calling for action against Mitchell. Sir James, calling for action, either jail or civil action. We found out, Sir James is here, we found out. We went to the High Court in St. Vincent, telling the High Court that this is bias. clear bias, naked bias, decided in favor of Gonzalez. Went to the Court of Appeal, clear bias, decided in favor of Gonzalez. Went to the Privy Council, and I hope Sir James will tell you this. Within a few minutes of the hearing in the Privy Council, Sir James told me, he wrote a note to me, this is different. This is different. The Privy Council set aside the High Court and the Court of Appeal decision. Set it aside, and today he will be able to tell you how he felt when he was getting injustice in his own country. So this has nothing to do with sovereignty, nationalism. Dr. Eric Williams, when he passed the Republic's Constitution, the country, some of the people in the country asked him, why would you keep the Privy Council? It is inconsistent with national sovereignty. It is inconsistent with nationalism. You know what he said? He said, justice is an international issue. The people must have confidence in the administration of justice. We live in a small society. Those were the effect of his words. We live in a small society. Everybody go to a cocktail party, and nothing is wrong with Trinidad and Tobago having appeals to the Privy Council. The best way for you to understand this, CLICO. We went to the court on CLICO. Policyholders, the government promised, the PNM government promised, told policyholders, don't take out your money, keep your money in CLICO. We guarantee you that you'll be paid your money. New government comes, said no, we offer you percentage less for your money, take it or leave it. Then they went and they passed a law to prevent policyholders from suing CLICO. In the evidence before the court, we had where the governor, the central bank said, what the minister said, what the prime minister said at the time. We won in the High Court. The Court of Appeal of Trinidad and Tobago held that based on what was said, there was no promise in law. Although the High Court related all the promises, the Court of Appeal held that what the central bank said, what the governor, the central bank said, couldn't bind the government, and reversed that decision of the High Court. Now, when you read that decision, any lawyer, anyone reading it in the Court of Appeal, with the greatest respect to the Court of Appeal, is a wrong decision. These people, the CLICO policyholders, have to go to London. The case is fixed for January. The central bank is offering them money now, but offering them less money than they're entitled to in order to try to make the case academic for them not to pursue their appeal in the Privy Council. Why should policyholders have to go through all this injustice to get justice? And I have no doubt that they would get justice in the Privy Council. None whatsoever. Let me give you another example. There was a former commissioner of police, and if you look in the law reports, you'll see many other examples. And in Trinidad and Tobago, in recent time, it had many more examples. Now, I have the greatest respect for the judges of Trinidad and Tobago, the judges of the High Court, the judges of the Court of Appeal, the judges of the Caribbean. But I have always taken the position, greatest respect does not mean to say that I have to agree with you and that I cannot criticize your judgments and appeal against your judgment. That is the duty of a lawyer. If I had apologized to Justice Sonny Maraj in 1975, every lawyer in Trinidad and Tobago today would have had to apologize to judges when they stand up firmly and fearlessly. So we are talking about an important principle here, and the principle is, are you going to take away the rights of people to access to justice, to their final court, which they enjoyed for hundreds of years, by you just coming and passing a law overnight to take it away? Is this going to be like how you went and you pass a law and you take away the people's rights to sue CLICO, or to take away the right to bail overnight? And that is why we are saying this involves people. This involves their right, and therefore, why are governments afraid to give people a right to say what I want or what I do not want? There was a former commissioner of police in St. Vincent. I'll give you one more example, and then I want to tell you what happened to Guyana when it abolished appeals to the Privy Council. And that is a fact. Those are facts, and those are near to home. And we are talking about removing the Privy Council at a time in Trinidad and Tobago when institutions have collapsed. When the population have no respect for what has happened to these institutions. A lot of them have lost their credibility, starting from the highest and going to the lowest. And we are trying to abolish the Privy Council, which have stood the test of time to give justice to people in the Caribbean for hundreds of years. Randolph Toucey. Toucey was Commissioner of Police. When Gonzalez became the Prime Minister of St. Vincent, he decided that he had to punish Toucey, because when Toucey was in opposition, Gonzalez wanted Toucey to do what Gonzalez wanted him to do. So he wanted to get back at Toucey. So what he did, he went to the Parliament and he said he decided to acquire Gonzalez's land in Canuan. Is it Canuan? Canuan. Yes, Canuan. Acquire Gonzalez's land in Canuan to build a learning resource center. But then he made a speech in which it showed that he really wasn't acquiring the land for that. He was acquiring the land because he wanted to get back at Toucey. So I do not know why I always get involved in these cases. Mr. Toucey contacted me. So I filed a constitutional case in St. Vincent. And I applied to the judge to use what Gonzalez said in the Parliament to show that the acquisition of the land was not for public purpose, but was to please and to satisfy Mr. Gonzalez's vendetta against Mr. Toucey. You know what the judges hold in St. Vincent? The judges hold that Gonzalez's right, he could claim privilege, parliamentary privilege, and the courts cannot look at that. And therefore, I cannot use that. I went to the Court of Appeal. They agree with the High Court. I went to the Privy Council, and the Privy Council said no. Say Mr. Toucey is entitled to justice. He wants to prove the Prime Minister in the Parliament did not acquire land for public purpose. This has nothing to do with parliamentary privilege. This has to do what the court has to decide. And Toucey won his case. Brothers and sisters, I want you to understand today that in Guyana, when Mr. Burnham made Guyana a republic country, he basically, after he made Guyana a republic country and he abolished appeals to the Privy Council, it is a matter of record that people ran, they flee Guyana because he became dictatorial. And why he became dictatorial is because he started to fly the party flag which he was leader of over the Court of Appeal. The judges were his judges. The courts were his courts. Persons had to run. People's lands were taken away. They got no compensation. Because when a government can use the court system to support its actions, then you have no justice. You have no rights. The media newsprint was taken away. He facilitated media which will only print what he wants to print. What you have in Trinidad and Tobago now, where this government is threatening newspaper not to give them ad if they don't publish a story, is joke to what Burnham did. I'm not saying that you would, if you have a court system in the Caribbean in which the judiciary would support prime ministers with whatever they do, then the people would have no rights at all. It will be another form of enslavement, another form of indentureship. And that is why today I am here. I am here because there's a threat that this right that the people have in Trinidad and Tobago can be lost overnight. Both the government and the opposition has taken the position, both the present government and the present opposition have taken the position that they would abolish appeals to the Privy Council without having a referendum, that they would just pass a law. That is the policy of the present position of the present government and opposition in Trinidad and Tobago. As a matter of fact, the present Prime Minister has rejected what the UNC policy was. And the UNC policy was always that the people would have a say in a referendum if we ever have to abolish the Privy Council. This Prime Minister went in April 2012 in the Parliament and said that her government has decided to go in a new direction. And that new direction is to abolish the Privy Council, and the first phase is to get rid of the criminal jurisdiction. So we have a situation in which both government and opposition are going to do that. And that is why I have decided to educate the population, because the people would have to put pressure for policies to change if you want to keep the Privy Council. This Prime Minister in 2010, if you read the manifesto, pages 12 and 13, said when we get into government, people would enjoy participatory governance. We will pass a law to have a referendum on major issues of policies. But having got into office, she decided to abolish the Privy Council without giving the people a right to vote. I don't want to get into politics this morning, but people talking about celebrating legacy. The legacy that we should be celebrating today, the government should be celebrating today, that they should have not wasted Parliament time with stupid motions, motion of no confidence. They should have passed a law to have a referendum in Trinidad and Tobago, and we should have had a referendum on the issue of whether we should remove from the Privy Council. I want to make it clear, I have no problem. The concept of the Caribbean Court of Justice is a very good concept. My position as Attorney General of Trinidad and Tobago, and Mr. Pandey is here, our position was that we would facilitate, as a government, facilitate the establishment of the court. But if it is that we have to accede to the Caribbean Court of Justice, the people would have to give a vote in a referendum for that as to when it is. We suggested that in order to build confidence in the Caribbean Court of Justice, because right now the people of Trinidad and Tobago have confidence, and then they had confidence, and they still have confidence in the Privy Council. Could you imagine what would have been Sir James Mitchell's position if he did not have confidence that he could have gone to the Privy Council to get justice? Could you imagine what would have been my position as a young lawyer with a young family, with babies, facing jail and the stigma of imprisonment? I decided that I didn't thief any money, I wasn't corrupt, I would stand up for people, and I would face the music. Could you imagine what would have been my position if I did not know that I could have gone to the Privy Council and get justice? What would have been the position of the CRICO policy holders today? The maxi-taxi drivers in Trinidad and Tobago move from one taxi stand, go to another taxi stand, Citygate, and you'll be able to manage it. Government, the same government, decided to change it and give it to the PTSC to manage it. The people went to the court, the High Court, and said, well, you made me a promise, you can't go back on it. I altered my position. The High Court decided in their favor. The Court of Appeal reversed that. Reverse that. These maxi taxi drivers had to go to London and they won. And poor people, they still can't get their money now. They had to wait. So I am saying that if you want the Caribbean Court of Justice, as we recommended, let some of the appeals from the Caribbean Court of Justice for a period of time go to the Privy Council. And let me tell you something here today. Do you know it is cheaper for a citizen to do a case in the Privy Council than to do it in the Court of Appeal? The legal fees are cheaper and the expenses are cheaper. And do you know now you don't have to go to London in order to see the case? You could stay in your house and see it online. You could see the hearing online. So, my brothers and sisters, as we embark on these discussions today, I want you to understand that this is a real threat. And I think that we have limited time for each speaker, and therefore I would end now, and I would call on Ms. Michaela Pandey to address you. Thank you very much.
Thank you, Mr. Chairman. Honorable Prime Ministers, specially invited guests, members of the media, friends, well-wishers, it is indeed a privilege to be here with you this morning. Let me begin by saying thank you for this kind invitation to participate in today's discussion on whether the Caribbean Court of Justice should replace the Privy Council without the consent of the people obtained in a referendum held for that purpose. Ladies and gentlemen, it is imperative before there is any debate on whether or not the Caribbean Court of Justice should replace the Privy Council as our final court of appeal to determine who should make the critical decision whether to abolish or retain, the government of the day or the people. In my humble view, the answer is simple. It is the people. The Caribbean Court of Justice should not replace the Privy Council without a general vote by the electorate on that single issue. In other words, it should not be replaced without a referendum. You see, ladies and gentlemen, we must not only preach democracy, we must practice it. And what purer form of democracy is there than direct democracy, whereby the people can participate directly in the decision-making process regardless of color, creed, race, religious beliefs, gender, physical ability, and/or party affiliation, without having to wait for 5 years to register their opinion. And so it is therefore vital that we, the citizenry, are equipped with the knowledge required to make that informed decision. The issue of whether or not we here in Trinidad and Tobago should abolish the Privy Council as our final court of appeal has been an issue of contention for many years, not only within the legal fraternity, but amongst politicians, political commentators, analysts, and the like. Ladies and gentlemen, under Section 53 of our Constitution, it is Parliament that makes laws for the peace, order, and good governance of Trinidad and Tobago. It is therefore Parliament that has to pass the necessary constitutional amendments to abolish appeals to the Privy Council and to make the Caribbean Court of Justice our final court of appeal. The question which arises then is whether Parliament should act without the direct support and approval of the people as demonstrated by a positive referendum. That is to say, whether the sheer importance of so fundamental a change requires the direct participation of the population in such a decision. So, ladies and gentlemen, what exactly is the Privy Council? Under the Constitution, the Privy Council is our final court of appeal. It is an institution that is centuries old, comprising the finest judges in England and the Commonwealth. And it is accepted to be absolutely independent from political interference by governments of the countries that access its appellate jurisdiction, including the Caribbean. It is this independence from political interference that has to date engendered public confidence in the administration of justice. The fear obviously being, as we have witnessed in many other countries, absent public confidence, the administration of justice will collapse, which will be followed almost immediately by other institutional collapses, resulting ultimately in anarchy. So what role, ladies and gentlemen, has the Privy Council played in the administration of justice in Trinidad and Tobago? Historically, as Mr. Mirage has said to you, the Privy Council has sought to enlarge the rights enshrined in our Constitution and not restrict them. In fact, fairly recently, as we have mentioned before, there have been numerous cases in which the local courts refused to grant relief to aggrieved claimants in the Privy Council. And in those cases, ladies and gentlemen, firstly, the Privy Council ruled that it was unlawful for the Trinidad and Tobago government to refuse to pay the salaries of opposition MPs in the 1818 electoral tie, and held that the right to salary arose at the time of election and not when the oath was taken in the House. 2, held that it was unlawful for the government to refuse to implement the Equal Opportunities Act, you will remember, which had been enacted and proclaimed by the President and by the then UNC government, as the Equal Opportunity Act, according to the Privy Council, was not unconstitutional. 3, in a novel step, you will remember, they ordered that a radio station be granted a license forthwith to operate in circumstances where the radio station was discriminated against in its application for a license. 4, held that, as we had discussed previously, the one-man commission of inquiry in St. Vincent and the Grenadines was biased against the former Prime Minister, who was a subject of the inquiry, and prohibited the commissioner from continuing in the inquiry. 5, held that it was unlawful for the Speaker in St. Vincent, as Ms. Mirage previously discussed with you, and the Grenadines, to refuse leave to a claimant to use the Hansard to prove the government's motive in compulsory acquiring his property, and was improper, they stated. His property was improper and not for a public purpose. 6, ladies and gentlemen, the Privy Council held that unless the Caribbean Court of Justice was given by the Jamaican Constitution itself the same status and protection as the High Court of Appeal in Jamaica, it was unlawful to replace the Privy Council with the Caribbean Court of Justice by a bill passed with a simple majority. Ladies and gentlemen, the thread that runs through these examples is the Privy Council has never shirked from its duty to uphold the rights of citizens who have challenged the might of governments in small societies, thereby strengthening democracy and public confidence in the law and the administration of justice. Ladies and gentlemen, it was the Privy Council and not the local courts which held that the amnesty granted to the insurgents in the 1990 coup attempt was invalid and of no effect. And contrary to public perception, the Privy Council in fact has never sought to abolish the death penalty, but has instead held that it must be carried out expeditiously and that it must be incumbent upon the state to ensure a system of justice that commits all appeals made by convicted killers to be dealt with expeditiously. It is therefore arguable that by its judgments, the Privy Council in certain cases have prescribed a model of governance which is perhaps more advanced and enlightened than the governance practiced locally. It is also arguable to the average man, all of the examples mentioned above accorded with common sense, fairness, decency. And so he must ask himself the question, why did they see the obvious when our local courts did not? Ladies and gentlemen, I make these comments and observations without casting aspersions on the competence of the local courts, even though I must say statistics suggest that the number of times the local courts have been overturned by the Privy Council is quite high. But to bring to the fore the critical need for public confidence in the justice system. Ladies and gentlemen, what about timing? Can it safely be said that public confidence in our institutions, the government itself, the regulatory agencies, the police service, the health service, to name a few, is so high that Parliament ought to take a bold step without the direct approval of the people themselves? We need only look, ladies and gentlemen, at the current state of disrepute the legal profession finds itself entangled, involving the alleged unethical conduct of attorneys involved in prison-related lawsuits against the state, commonly referred to as Prison Gate scandal, where the Solicitor General was left no choice, ladies and gentlemen, but to submit a letter to the Prime Minister advising that an investigation be conducted into matters involving lawyers engaged in prison litigation. And ladies and gentlemen, let us not forget the most recent scandal of lawyers allegedly being paid at least almost $500 million in fees over a 5-year period from the Attorney General's office, which alarmingly excludes fees paid to lawyers for services rendered to state enterprises. Ladies and gentlemen, a referendum in such circumstances that speaks to the heart of fair administration of justice can only be a step forward in the right direction. I therefore humbly suggest the issue of the Privy Council I humbly suggest the issue of replacing the Privy Council with the Caribbean Court of Justice ought to be settled by the people themselves and not by their political representatives in Parliament. For that purpose, we, the people, must be informed. We must be educated by the history, by the facts, by the statistics, by an understanding of the contribution made by the Privy Council to the development of our nation. It is for the people alone to decide whether they wish to take that bold step.
To the platform, I will change it over a bit. The former Prime Minister of St. Vincent and the Grenadines, Sir James Mitchell. Sir James.
Thank you very much, Mr. Chairman. Colleague, former Prime Minister Pandey, Honorable Jack Warner, other distinguished members of the panel, ladies and gentlemen. I wish to thank my lawyer Ramesh for inviting me here. I wish to thank you, the media, for coming. And once more, I want to thank Trinidad and Tobago for the part you played in my education in the grand old institution called the Imperial College of Tropical Agriculture, run by the English, where when you failed one subject, you went home. So when I present myself to a Trinidad audience, you got to know any misbehavior that I perpetuate in your presence was learnt right here in Trinidad and Tobago. Ramesh and my daughter Louise were the ones that went all the way with me to the Privy Council, and I won. I am not here to boast about that victory. I am here to share with you the grief I have about Caribbean justice, that your humble servant, 35 years in Parliament, enacting all kinds of legislation for the courts to look after, I could not get justice in this Caribbean. Let that be a lesson to the people. If my Commissioner of Police served 44 years as a policeman, and the longest serving Vincentian Commissioner of Police couldn't get justice for his constitutional rights, and I couldn't get justice, what about you? Now, what got me into this mess? I decided, with my long tenure of office and dealing with the Europeans, the World Trade Organization, the American multinationals, and all involved in the banana industry, that I knew that our preference was going to end and that I had to diversify our economy. And one of the places I decided to go was to develop our marine resources. I grew up in the Grenadines in a seafaring family. My father vanished in the Bermuda Triangle, and all the wealth my family possessed is what we got out of the sea that we brought into the land. And so I decided we had to diversify into the development of marinas and ship servicing facilities. In the Italian Foreign Ministry, I was told as Prime Minister, we will not support your bananas forever. You must diversify. And we have a good project that we will support with Italian export credit guarantee. I heard that from the Italian government. I was introduced to the banks. The representatives in Italy of a German bank called West LB. And they said they would provide the money. You have a little country like St. Vincent, and you're seeing these new opportunities arising, knowing the doom awaiting your banana industry. At the peak of our banana industry, we used to make 100 million a day. Yeah. Now if we make 2, we make plenty. I went and I saw the parent facility of the company that was prepared to build a shipyard in St. Vincent. A company had been functioning since 1912 in Italy, near to Genoa, in a little village called La Grazia. I said this was the way to go. When you get an export credit guarantee facility from a government, that government has to sign to give you that export credit guarantee facility.
And so the project was signed by me on behalf of St. Vincent and the Grenadines and the Italian government. And then they set up an inquiry, and one of the things they said in this charade is that I did not do due diligence. Was I supposed to do due diligence on the Italian government, a little St. Vincent? Was I to do a due diligence on the big German banks and other Italian banks? I was satisfied. They said I had to put in an input into the project. I had to put in 15%. I put in the seabed and the beach and a piece of the land, an acre of land. You want to tell me that such a thing was not well conceptualized? And before I left government and we ran into difficulty, I went back to the Italian government and got 50% of the debt written off of the 50 million US. We got 33 Vincentian trained in Italy in how to operate the shipyard. The shipyard was built. Shipyard was functioning while in government. You can look on the internet and see the Otley Hall shipyard advertised as it has been advertised from the date of conception. Many Trinidadians would like to buy it over, but because of the confusion of inquiry, it is still there. To carry an ordinary ferry boat in there is 100,000 EC a week. And that was functioning while I was there. But they set up an inquiry to look into this project with me as the prime suspect. First of all, they sent me an invitation and asked me to supply the documents. I'm giving you this background so that the legal part of it is dealt with Ramesh, but I have to give you the background to see what they're going on. You have something functioning, and you decide to set up an inquiry saying it's a failed project. It was an incomplete project because some of the facilities that were supposed to be put in, all the money did not come. But the project was functioning. They wrote me and asked me to supply the documents. I said, I have no documents. They're all in the Prime Minister's office. And then Ramesh got involved and they asked me to testify. We asked them to send us what they want from me. They never replied. In 12 years, they never replied before it reached the Privy Council. They wrote an interim report, released it a few days before the 2005 election. And the title of the report was Possible Criminal Acts and Offenses by Certain Individuals. Sent it to the DPP. They wrote a report, ladies and gentlemen, without seeing me, without hearing me, without sending me a copy of the report. And we pleaded that this was bias or apparent bias. Let me give you the sequence. I had to go to the courts in St. Vincent, St. Lucia, Antigua, Dominica, up and down, moving the lawyers and getting judgment. We went before one judge. He threw out the case. Right there we asked him, Ramesh asked him to give us leave to go to the Court of Appeal. He said no. So count one judge. Secondly, we had to go to the Court of Appeal to get permission to go to the Court of Appeal. Then we went to the Court of Appeal, all the way in Dominica. And the Court of Appeal said, well, they think Sir James has a case. It should be heard again. And the lawyer, as we were leaving the court, said something in the court. The lawyer for the government said, Sir James is an icon, we better be careful with him. Anyway, so we go back to the lower court. And the lower court threw it out again. Then we went back to the Court of Appeal. And the Court of Appeal threw it out again. And then I had to go back to the Court of Appeal to get permission to go to the Privy Council. I went before 9 Caribbean judges, former Prime Minister Mitchell, and I did not get justice. I got it in the Privy Council. For me, it was very exciting seeing the presentation with the legal team in London, etc. And the lawyer they had in the Caribbean pleading for the government's case didn't turn up there. But one of the judges on the 5 Court of Appeal asked the lawyer representing the government, in this report, you have a sentence which reads as follows: the evidence so far, which has not been refuted. Will you please explain what you mean by so far? All he could say, milady, an unfortunate sentence. 9 judges in the Caribbean, now 1. And the DPP in St. Vincent was a former chairman of the governing party's political party, the DPP. And the entire legal system in St. Vincent, the Bar Association, objected to that man being DPP. And he was appointed. How he got there, you can speculate. So, that was my case. And you can get it all on the internet. Privy Council case and judgment 0067/2013. Now, what I have recounted to you, the sequence of events that I have had to face for 12 years. And let me say, I must be made of something tough. In all the years of inquisition and harassment and political vendetta, I slept well. The night Ramesh called and told me we won, I couldn't sleep. The question is, what, ladies and gentlemen, does my experience mean to you in this Caribbean? Are we going for national identity or vanity? Time we do our thing. You in Trinidad have your national identity. You're the only country in the Western Hemisphere that invented a musical instrument. I don't know if you know it in that context. The steel drum is the only new instrument invented in the Western Hemisphere. Everybody got drum and flute and everything. Look at the experience of the other government in St. Kitts. Having to go to the Privy Council to rule in respect of the procedure for election, with a government for 2 years that refused to entertain a no-confidence motion. and doing all kinds of irregularities and the boundaries up to the last minute. Would the Caribbean Court of Justice be ready to take a decision 3 days before an election? If the Privy Council was not there, and let me say, the same judges who turned me down in the Court of Appeal are the same ones that turned down St. Kitts, you know. And if you were to get judgment, justice appointed at the CCJ, they have to come from the whole Caribbean with that kind of experience. But your scholars like Cyril Ryan and others have spoken about it, you know, that it is the Privy Council that has allowed democracy to prevail in St. Kitts and Nevis. We want continued democratic choice. As I see it, the Privy Council was my last resort. Thank God it was still there. When I fought against the changes of our constitution in St. Vincent, I never knew then that I would need the Privy Council. As I said in the beginning, I say again, and I'll never tire of saying, I grieve for justice and the administration of justice in our parts. Among the things that we need, I'd like to make a recommendation, is that we set up statistical offices in the ministries of justice or in the court system to check on the length of time it takes to get justice and record the sequence, and let's build up a proper analysis. All those people, young people in the university, go and study that, analyze that and see where justice is going. If I didn't have the resources to go all the way to the Privy Council, I would not get justice. And I've had to use my own resources and my inherited resources. I've been in the family for over 100 years to get justice. And the government uses the taxpayers to go after the citizen. Taxpayers' money. Privy Council awarded me cost. But let me add one other input into the kinds of things we have in government going on in the Caribbean. After the Commission of Inquiry was established in St. Vincent, the government of St. Vincent, with the inquiry already going on, goes into Parliament and enacts legislation to say that the people involved with the Commission of Inquiry, etc., must not have their legal expenses paid. They enacted legislation to deprive me of my legal expenses retroactively. And what was my sin? They couldn't beat me. I retired undefeated. But with all of that, I don't mind. I have studied the history of trials, Jesus Christ, Galileo, and all of them down the line, and that fortified me. Reading about inquisitions was my hobby while I was harassed. I come back again. So they enacted that legislation, all stages in one day without the opposition present. Privy Council looked into all of that, and they said, we award you costs before the board and in all lower courts. I need that money, and I need to get to retrieve my wastage of funds. I
I want to say all of this is related to our democracy and our quality of life. I just want to say one other thing about referendum. The people of Malta recently held a referendum to vote on whether or not the hobby that they had in Malta of shooting pigeons flying over Malta to go to Africa. They had a referendum on that. A simple matter as that. Why? The question is, why are my successors in Parliament scared of the voice of the people? Thank you.
Michelle, a round of applause again for him, please. I'm going to bring to the microphone now, no stranger to Trinidad and Tobago. He needs no introduction. The Honourable Mr. Jack Warner, Member of Parliament for Chaguanas West and Leader of the ILP.
Thank you, Mr. Chairman. And all those distinguished speakers who spoke before me and who will come after me. And you distinguished people in the audience, I must confess, until David Abdullah came, I felt a bit lonely. I felt very lonely as being the only political leader sitting in the back there. No one to discuss politics, no one to talk about Kamala, past or present, and therefore I want to thank him particularly for being here this morning and for saving the day for me. But let me be honest with you, as I always try to be. I do not see in any way any government in this country could have access or have the Privy Council abolished as the last line of appeal without the consent of the people. And I am talking here not about a manifesto consent, I'm talking here about a referendum where the people have to decide if in their wisdom or lack of it they want to give up the Privy Council based on the record of the Privy Council vis-a-vis cases in Trinidad and Tobago. I want to also say that I am not in any way making any indictment against the local judiciary. But all of you will agree that the perception exists in society. The perception exists that almost all our institutions in this country have been compromised in some way or the other, except possibly TV6 and the Express, and of course the Sunshine. Every other one. And therefore, whether it's true or false, you have to admit that you have to go to the Privy Council, which is detached from the local society, from the Caribbean society, to get judgment. I'll give you two examples where I, of course, looked at the Privy Council in a different light. I was not even interested before. And one example involves Ramesh Lawrence Maraj. I was then Minister of Works and Transport. As Minister of Works and Transport, we wanted to build a highway past Omira in Arima. And the government wanted to remove a shop from the corner to take the land from the shop. They had given the shop Form 1, Form 2, Form 3, that offered the guy, I think it's $800,000. He refused and so on. He had been there for some 25, 30, 40 years. And the government said he has to move for development. And the guy, the government took him to court. He lost. He went to the appeal court and he lost. And then he took Ramesh and went to the Privy Council and he won. And the fact is The guy is still on the same spot today, and the highway is going up as usual, as normal. If he didn't have access to the Privy Council, where would he have been today? Where would he have been today? And as I was perusing, in fact, before I continue, that very same case that Sir James Mitchell spoke about in St. Kitts Nevis, where they lost in the High Court, and they lost in the Appeal Court, and they came to the ILP for help, financial help, and we held them to get to the Privy Council, and they won 3 days before an election. And therefore the boundaries in St. Kitts Nevis could not have been changed to facilitate the outgoing government. You think any Caribbean Court of Justice would have given a decision like that 3 days before an election? I'll leave the rest to your judgment. All I'm saying is, like Dr. Williams said, these guys drink in the same places, they knock glasses together, they have their cocktails together, their parties and so on. In a small society, they have their friends. My friend is your friend. And therefore, one can imagine that it's very easy for them to become compromised. Before coming here, I reviewed several cases at the Privy Council through my chairman, Rika Ramjit, attorney at law. And in all those cases I reviewed, I saw 3 examples. One of course, criminal, one civil, one malicious damage, as they call it. And in each case, I look at it, these cases were tried here in the High Court, in the Appeal Court, and were won in the Privy Council. One case involving Calix and the AG, I won't go into details this morning. Another case with Universal Foods against the AG. And the last one, a murder case with Dennis Benjamin, and the AG. In all of them, decision was reversed. And therefore it gives me, if not before, it gives me, as political leader of a party aspiring to be in government, to say to you this morning 2 things. In the first case, we have said and continue to say that in this country, there'll be no new government without the ILP. None. Absolutely none. And in the same breath we say that there'll be no new government that could bring in the abolition of the Privy Council without the ILP's consent. And we will not consent to that unless through a public referendum. But it's not only a referendum, you know. It's not only a referendum. People must not only be asked to vote for or against the Privy Council, but you have to educate them. Let them know the good, the bad, and the ugly. Let them know why the Privy Council should be retained. Because far too often, people vote on issues and they don't even know what they're voting for. I see people go to the parliament and you ask them, what you come here for? I come because she's nice. What you come here for? I come because they send me. What you come here for? Well, CPEP, we get the day off, so I come down. Don't let anybody vote on this issue that way. It is too critical. It's life and death, friends. And we have to spend money to educate them throughout the length and breadth of the country. And Ramesh, whether you had the money or not, you better find it. Find it. And the last but not least, I want to say, as I sit in the parliament week after week, and I watch the speaker, Wade Mack, I wish we had a Privy Council for speakers. Up to last Friday, that man embarrassed himself. In my motion against Hawaii, he was a monumental shame. Last Friday, a debate in progress, and he wants to accede to the Prime Minister's wish for motion of no confidence against Rowley. Debate ain't even start yet. Imbote ain't even talk yet. Jack Warner ain't even parade yet. But he wants to take a motion from the Prime Minister. And hadn't it been for the persistence of Imbert and Marie McDowell in particular, who knows, that will pass. So I ask you today, find for me, help me to find some Privy Council for Wade Mack. I thank you.
On a round of applause again for Mr. Warner. I merely wanted to make an announcement. Those who are listening and those who are here, I have an important announcement to make at the end of the meeting to all CRICO policy holders. So bear with me until the end of the meeting. The next speaker is no stranger to Trinidad and Tobago. He has made an indelible mark as the Prime Minister of Trinidad and Tobago, and before that, as you know, he was one of the greatest people's man, if I may use that expression, accessible at all times by the people of Trinidad and Tobago. I have great pleasure in bringing to the microphone Mr. Baste Pandey.
Sounds a little raspy. It is because within the last year, I found out that my voice was deteriorating. So I went to the doctor, and after he examined my throat and my history, he said that I know what is happening to you. What? He says, for 30 years, you've been shouting at people from a public platform at the top of your voice for 30 years. But for the last 5 years, you've stopped completely. And your voice, Mr. Pandey, is like other things. You use it or lose it. Distinguished former Prime Minister of St. Vincent and a friend of mine, Sir James, Chairman, other distinguished guests, brothers and sisters, friends and foe alike, welcome. I want to make it pellucidly clear from the outset that this meeting is about a single issue, and only one issue alone, and that is whether the government of Trinidad and Tobago, this one or the next, should abolish appeals to the Privy Council without first going to the people by way of referendum to find out whether the people want to abolish the Privy Council or not. If later on in the week, I know there's politics in the air, and if later on in the week or the month or the year you want to talk about something else, I shall be willing to attend that meeting as well. But today is about whether the government should abolish the Privy Council without first going to the people by way of referendum. You see, I'm almost getting back my voice. There are several countries in CARICOM, including Jamaica, that has not made the Privy Council their final court, not abolished the Privy Council for one reason or another. And there are several of them who have not accepted the Caribbean Court of Justice as the final court of appeal. Well, as you know, I don't have to tell you, from time immemorial, since we were a colony, the Privy Council has been our final court of appeal, and our people have grown to develop a certain confidence in that tribunal. And that, my brothers and sisters, is the essence of a proper judicial system: confidence. That is what it is, confidence. People must have confidence in the courts of law. If the people do not have confidence in the law courts, in the law and the courts, They will not go to the courts when they have into their own hands. Aren't we seeing much of that taking place today in the country? Look how many people prefer to chop and kill their neighbor rather than go to the court over a simple boundary dispute. They take matters into their own hands because they feel they will not get justice before the courts, or it will take too long to get that decision, or it is too expensive. Confidence in the court is a must for every civilized society. That is what this meeting is about. Do you have confidence in the Caribbean Court of Justice to be the final court of appeal? If you do agree, then the Privy Council should be abolished. But you may not agree to that. As a matter of fact, some people may agree and some may not. But that will always be the case in any free society. People are never of the same opinion. On any issue, some will say yes, and some will say no. Some will say that we must go this way, and some will say we must go that way. How, therefore, do you decide which way to go? In a democracy, you go the way the majority says we should go. It is the only method by which you could make a decision to move forward. Otherwise, there's a stalemate. If so, how are you going to determine the majority view? That is how and when the referendum comes in. What is a referendum? A referendum is a direct vote of the people. There is nothing more powerful, nor indeed more just, in a democracy. In a referendum, you submit in its simplest form a question for the people to answer. They will indicate their answer by voting on a ballot paper, indicating what they wish. The ballot paper, I suggest, humbly, if we are going for a referendum, and I'm saying this because governments may agree to a referendum and then have such a complicated referendum that people don't know what they're doing. So the question on a referendum must be short and simple and precise and exact. So therefore, I suggest humbly that the ballot paper in this case should ask the simple question: do you agree that the Privy Council should be abolished as the final court of appeal in Trinidad and Tobago? That and that alone must be on the ballot paper. It must not be complicated with which prime minister you think more popular than the next one. And when you have a ballot paper that asks that simple question, it has a box that marks yes and a box that marks no. And you simply put an X by your choice, and that is it. It is not a difficult exercise. All you have to do is to make sure that someone does not pad the ballot box. So that's the next question if you're having a referendum. We have a tremendous capacity in this country for padding ballot boxes. And I should know. In order to ensure that the decision truly reflects the wishes of the people, they must know and they must understand the issues involved. We must educate, therefore, the people on all aspects of this matter. I therefore humbly suggest that we embark upon a series of public meetings to educate the people about a referendum and about the need for a referendum on the Privy Council. That, of course, will involve some organization. And, of course, it cannot happen by itself. I would suggest, therefore, that we set up a small committee. Sorry, I said we. I meant you. That you set up a small committee to put in place the organization required for that exercise, to hold a series of public meetings explaining to people what the Privy Council is about, what a referendum is about, and the need for it. That, my brothers and sisters, is my humble and simple advice. Thank you for listening.
Mr. Base Pandey, can we have a round of applause again for Mr. Pandey? After the meeting, we have a desk, Democracy Watch, and we plan to have public meetings on this issue and other issues throughout Trinidad and Tobago. Those persons who would like to offer to help us with that, they can go to that desk, because Mr. Pandey has made a very important suggestion. I think that this issue is an issue which needs a coalition of people, issue, and we would want assistance, and we welcome people from all walks of life, all political parties, and it doesn't matter because this is not a party political issue. Our next speaker is the leader of the MSJ. I was about to say the leader of the ILP again, you know. Is the leader of the MSJ. He needs no introduction to you. He's Mr. David Abdullah.
Thank you very much, Mr. Ramesh Miraj, chair of this morning's very important activity. Very distinguished colleagues on the platform, and Jack made a point about my giving him some company. There is one difference, however, that with the exception of the two young people at either end of the seated group on the stage, all the others were elected members of parliament at one point in time or the other. I alone have not yet been, though I contested elections the same time that Nizam did in 1976, way back in the original ULF. But we'll change that very soon. I want to thank Democracy Watch for organizing this very important education activity. As Mr. Pandey said, education is vital, particularly in a culture where, and in a time where those who hold office abuse that office by trying to change the conversation, by trying to shift focus of attention from the real issue to something else. So you want to debate a matter dealing with corruption, and they shift it to something else about somebody's personality. You want to debate the issue or raise the issue of HDC housing, and the minister get up and chat some other nonsense to shift people's focus. So we in Trinidad and Tobago have to keep focus on the issues, and thank you, Ramesh and Democracy Watch, for doing that this morning. I am not a lawyer like many of the distinguished persons who have spoken before me, so I also am going to focus on the politics of this issue, not politics in terms of party and so on, but politics in terms of power. How are decisions made, and in whose interest do those decisions get made? And I want to situate this issue of the Privy Council in the wider context of the justice system and also governance and the institutions of state. And I want to talk about where we are this morning in terms of decision making, that the process by which a decision is made is more important than the actual outcome of the decision. In other words, how we come to make decisions. Do people participate, or not? And therefore, do citizens have the opportunity to buy in or make themselves feel that the decision that is being made is their decision and therefore take ownership of that decision? Or do we feel that it is somebody else making the decision of which we are completely separated and disengaged from? And at root of the problems of Trinidad and Tobago today, and indeed the Caribbean, is that problem that we, the people, are not part of the process of making decisions which impact upon our lives every single day. That is a root problem that we face. And I want to go to the Constitution of Trinidad and Tobago, which we often don't think about, which says in the preamble, we, the people of Trinidad and Tobago, we have asserted their belief in a democratic society in which all persons may, to the extent of their capacity, play some part in the institutions of the national life and thus develop and maintain due respect for lawfully constituted authority. One of the reasons why Trinidadians and Tobagonians have very little respect for lawfully constituted authority is because we have no say and play no part in the institutions of national life. So it's them people over there, the government decide, and so on. But we don't feel a part of that decision, take no responsibility therefore for it, and have no respect for not only the decision, but the institutions. And where are we today? We are in a situation where more and more brazen criminal acts are being committed without anyone being arrested, far less convicted. How many of us remember that more than a year has passed since the cocaine in juice cans case took place? More than $600 million of cocaine left Trinidad in juice cans. Not a single person arrested. Remember all the hoopla? DAs here, DAs involved, arrest imminent, high priority. More than a year, nada. Almost a year, 11 months I think and 2 weeks since Dana Sitahal was murdered. You remember all the hoopla? Top priority case, we're on the heels, we have CCTV footage and so on. Commissioner of Police said all the resources of the police service will be used to find the killer. Outrage. What has happened? Nothing, nada. None of the investigations into the many allegations of misbehavior in public office and or straight out corruption have been concluded. $400 million life sport, 34 million of which paid to one person to do classes that never were held. Nobody penalized. From Calder Hat to Beetham Wastewater Project, Email Gate, Prison Gate, Tea and Tech chair. You buy the chair, Jack? But don't sit in it. I think he wants to get the massage that the speaker's wife was getting, but we leave that alone. NGC ads, corporate communication ads, Shagaramas leases, the list is endless. These matters are being dragged out with no end in sight, leaving citizens no closer to knowing if wrongdoing took place and who, if anyone, was culpable. The courts are clogged with cases. Matters take years to be completed, and many more crimes are committed that never ever reach the courts. In fact, the justice system is broken and does not deliver justice for all. The institutions of parliament and cabinet have become a farce and mock the intelligence of the people of Trinidad and Tobago. From the statement by Vernella to the speaker refusing to send her to the privileges committee to all those other things that are happening. The institution of the police service can't catch the big criminals and murderers and bring them to justice. Corruption flourishes under the nose of the system set up to maintain integrity in public life. In fact, we have an integrity commission that does not guarantee integrity in public life. And so many of our other institutions, healthcare, education, and so on, are in shambles. We have to ask the question, Brother Chair, sisters and brothers, why? In our view, it is because the First Republic is finished. The Republic of 1976 is finished. The institutions of state created by that Republican Constitution cannot deliver on the promise of the preamble to our Constitution. And therefore, we need major reform to bring about what we call the Second Republic. Our institutions, you see, were established, were designed in the context of a colonial society. These institutions did not have as one of its objectives promoting equity or an inclusive society. Neither was it based on participatory democracy or giving people a sense of ownership, but rather to maintain the old colonial status quo. We believe that in changing our institutions from being agencies which preserve the colonial society to progressive bodies which foster equity, the entrenched relations of power within our country will be transformed. And this transformation will therefore break the trend which now prevails, where those who wield political, economic, and social power abuse and misuse their offices to promote their own interests at the expense of the national interest. So we therefore have a situation where in colonial days, what happened to Sir James would have happened because the colonial authorities would have said, know your place. As happened in Guyana, where the colonial authorities suspended the Constitution in 1953, detained under a state of emergency all the elected officials led by Cheddi Jagan and put in colonial direct rule. But that sense of abuse of office by the colonial power was replaced by individuals who are locals but have the same power and therefore can abuse that power in their own interests. And that is what has been happening throughout the Caribbean. And so we have to transform the relations of power so that we move away from maximum leadership to maximum participation. Governments can and do change. However, the state and its institutions remain constant. So unless our institutions are reformed, unless the governance process is changed, then irrespective of which party wields office, we are going to have the same problem. And so changing the system is crucial. Our national constitution establishes the framework of rules, principles, and laws for managing our affairs. And we believe that the framework must be one that fulfills the objective of social justice as expressed in the preamble. But the question is, how do we bring about change to the Constitution? In our view, there must be a proper process, because process is as important or more important than outcome. And what is the process that we are proposing for constitution reform? Firstly, a secretariat. And the secretariat would then engage in public education, because the average citizen, in fact, most of us in this room, if we asked us, what does the Constitution provide for? Most of us would struggle to answer that question. So we need public education so that every single citizen will know not only what does the existing Constitution provide for, but what are the options for executive power? What are the options for having a parliament? What kinds of legislature can we have? Because there are different forms. What are the options for establishing a judiciary? What are the options for establishing a public service and a police service? Who appoints and so on? Let us put down those options and then have national debate about which option is the best option for us in the context of the nature of Trinidad and Tobago, which we have to say and recognize is a diverse society. Because the reality is that West Moorings is not Laventille, and Samoa is not Debe, because we have many different Trinidads, and Tobago is not Trinidad. We have many different Trinidad and Tobagos, and we need a constitution that enables all of us to feel that we own this place and take responsibility for it. and we have the checks to prevent the abuse of power. So we need that public education. And then out of that, a draft constitution. And then further public dialogue on that draft. And ultimately, public approval through a national referendum. So a national referendum, and Mr. Pandey is absolutely right, has to be clear. National referendum on the Constitution. And then, let me then, because I know that my time is running out, say very specifically with respect to the issue of the Privy Council, that the MSJ's position is that the Caribbean Court of Justice must be fully established as the final court of appeal in both the civil and criminal jurisdictions. However, since the final court of appeal is established by the Constitution, which is why I spoke about constitutional reform and the process to get it, consistent with our position on the reform process of the Constitution, you cannot extract one element of constitutional reform. And this government, Brother Ramesh and colleagues, this government seeks to tinker with the Constitution here and there when we really should be looking at it in a holistic way. But consistent with our reform process, the issue of changing our final court of appeal from the Privy Council must require public debate and a referendum. That is our written position, and we took this position 9 months ago. So it is not a position that we took for today's forum. It is our consistent position with the idea that unless we get participatory governance in Trinidad
on the Caribbean Court of Justice, a very useful article in which he stated that the arguments for and against and what people in Trinidad and Tobago are saying and in the Caribbean. And Dr. Fenton Ramsay, who was in Guyana when Burnham started and abolished the Privy Council, this is what he had to say. So in the meantime, people can pass the water and I can read this, and Mr. Nizam Mohammed will address you just now. Nations, and I quote Dr. Ramsay, nations do not always benefit from experience. West Indians have seen with their own eyes the destruction which came to pass in Guyana after appeals to the Judicial Committee of the Privy Council was abolished. The result has been subversion of the rule of law and the democratic process there. This destruction of Guyana could not have come about without abolition of appeals to the Privy Council. Premature abolition in other territories of the West Indies will bring no different result from what happened in Guyana. It will, when it comes about, mark the beginning of the end of our institutions of government. Dr. Ryan also referred to an editorial in the Trinidad Guardian in 2001, and I quote, "Appointments to find a final appellate court which replaces the Privy Council cannot be made in the hope that an appellate court or the appointee will become distinguished by virtue of the appointment and its establishment. The appointee ought to be required by the West Indian country to be distinguished in the learning and practice of the legal profession years before appointment, with a character, integrity, and independence which are unassailable and recognized by the community to be so. This is not a time for the community to bow to the dictates of nationalism. What is required is studied restraint. It is laudable to aspire to and to establish its final appellate court. It is unfortunate the idea is being advanced or made worthless by the evil of prematurity." I have no hesitation and I have great pleasure in calling Mr. Nizam Mohammed, an attorney at law and former Speaker of the House of Representatives. Thank you very much.
Thank you very much, Mr. Chairman. Distinguished former Prime Ministers and my other distinguished friends on the platform, ladies and gentlemen, I swear to you that when I was jotting down some points that I want to share with you here this morning, I did not confer with Mr. Basdev Pandey. The question that we are asked to consider, as Mr. Pandey has said, is a single question, and that is whether government ought to replace the Privy Council without the consent of the people obtained in a referendum held for that particular purpose. I do not believe that the idea of the Caribbean Court of Justice becoming the final appellate court for all Commonwealth Caribbean states is one that is hard to sell. The real problem is whether such an idea has been properly and effectively canvassed so that the population in any Commonwealth Caribbean state is sufficiently apprised of the advantages of such a replacement. The first imperative is to ensure that there is the clear establishment of public trust and confidence in the administration of justice at the level of the CCJ as our highest court within the system. And this cannot be achieved by Trinidad and Tobago merely becoming a signatory to the agreement establishing the court with the usual ceremony and fanfare. The government of the day must ensure that the move has the confidence and the support and the input of the people. And there is only one way that this can be discovered, and that is through a national referendum held specifically for this purpose. Many people skeptically view the integration, view Caribbean integration as an elusive dream, often sabotaged by self-seeking, egocentric politicians, often primarily concerned about protecting their local turf, thus confirming their imprisoned positions to insularity. I do not believe that for example, the University of the West Indies or the West Indies cricket team have done much to the integration efforts in the last 2 decades. I cannot see how the CCJ, with the best of intentions, can do anything meaningful to enhance the process in the present situation. It is therefore left to civil society to promote the idea. Lots of debates will emerge because reservations abound about such a court's independence and insulation from political control or political influence. I submit that the establishment of the Caribbean Court of Justice as our regional final appellate court is critically necessary for the fast forwarding of the integration movement, but care should be taken that we do not throw out the Privy Council before we are assured that we have a proper Caribbean Court of Justice to replace the Privy Council. Should there be public consultations prior to a referendum, a lot of knowledge about the Caribbean single market economy and the revised Treaty of Chaguanas in relation to the CCJ will be shared. If properly structured and the campaign can be canvassed regionally, our Caribbean peoples will be better prepared mentally and psychologically for embracing the CCJ, which will be a big asset to the CCJ itself. We will be forced to reminisce with some degree of nostalgia about the failed West Indian Federation in 1958, and we in Trinidad and Tobago will of necessity have to remember the Marlborough talks prior to gaining independence in 1962, with particular reference to the enshrined freedoms as guaranteed in the preamble to our Constitution. Before I end, I wish to mention that our Prime Minister, when in opposition some years ago, expressed reservations about Trinidad and Tobago accessing the CCJ as our final court of appeal. It will be interesting and rather informative as the discussions now gain center stage to be told what those reservations were. Perhaps the media can help us. In our deliberations, we will have to remember at all times that Trinidad and Tobago, when it comes to the administration of justice, Trinidad and Tobago is not Jamaica, nor British Guyana, or Guyana, Barbados. We are very unique, and we have to understand this as we continue the debate and the discussions. But I wish to indicate that a referendum on this particular issue is a must, and discussions with the people and debates on this particular issue must be held, and civil society has a responsibility to make this happen if the foundations of our democracy are to be preserved. Thank you very much.
Mohammed, and let us have a round of applause for Mr. Mohammed. The two last speakers are two young persons in Trinidad and Tobago who have been very involved in the new organization, Democracy Watch. And in addition to the perspective from a young person, Michaela Pandey, these two young persons would make two very short contributions to you to give you how they see it as young persons living in Trinidad and Tobago. I have great pleasure in calling upon Ms. Amina Rowland, convener of Democracy Watch.
With all protocols observed, I wish to extend morning greetings to all gathered here today and those tuned in at home. I am indeed honored to be here today speaking on the same platform as these distinguished gentlemen and lady. Today's meeting is one of utmost importance, as it is an issue which affects each and every citizen of Trinidad and Tobago. We are talking about the administration of justice in our country. The administration of justice, people. The process and structure which allows conflicts between parties to be settled by a body unbiased to all parties involved. One would think that living in a democratic nation and faced with such an issue like this, which directly impacts on the livelihood and the enjoyment of the fundamental human rights of citizens, that the citizens should have a say. Now, I can go on and highlight the functions of the Privy Council and all that it has done for us, etc. But thankfully, I'm on the same platform as the experts, so they kind of made my job very easy today, and they basically explained everything to you. So I decided to take a different approach. Being part of an organization that promotes democracy and is dedicated in having the people's voice heard, right, I decided to dedicate some time this week prior to this meeting, right, to get the opinions of the people on the streets. So I posed the question to them, whether the Caribbean Court of Justice should replace the judicial committee of the Privy Council as the final court of appeal. And this is what some of our citizens had to say. So a 28-year-old teacher, female, she says, there are always pros and cons to everything. Yes, the Caribbean Court of Justice would give us a sense of autonomy as a country, and the judges of the CCJ will have a better understanding of our culture, in addition to being regionally based and more accessible. But, she says, at the end of the day, there is always room for bias, and she is not sure that this is what she can accept. Then next we have a clerk, 23-year-old male. He says, they should keep the Privy Council. The Privy Council has more experience and has been around for a very long time. One of my concerns about the CCJ is who determines who is in charge and is ruling in the CCJ. We all know the Caribbean is corrupt, and it would make it easy to influence verdicts to suit political agenda. Next, we have an attorney at law, 33 male. He says, it is a good idea in theory to help to bring about integration in the region. However, it is unworkable because our society is so small that we are not immune from political interference. The Privy Council is in a better position to be dispassionate and apply principles of law. In effect, they are really establishing Caribbean jurisprudence, but perhaps not in the format advocates of the CCJ would want. A housewife, 40 years old, she simply puts it, the Privy Council can be impartial and not corrupted by politicians. A retired Coast Guard, male, 53, a little bluntly states that it is absolutely ridiculous and should not be implemented. Next, I have a lab technician, 48 years old male. The only hope any poor person has against a rich, powerful person in the West Indies is an outsider. No way would a CCJ rule against their families and friends. Poor people do not have relatives and friends who would be appointed to the CCJ. Use your God-given brains and fight to keep the Privy Council until such time, which is not anytime soon, that equality and checks and balances would really exist. An oil field worker, 33 male, he says, to remove the Judicial Committee of the Privy Council is not in the best interest of the people because of political influence. The Privy Council is completely independent. The local judiciary, to some extent, has already been tainted due to political influence, and the CCJ will act like a regional local court, which our government will obviously be a part of, and as such, open to bias. I think we should keep the Privy Council to be safe. And lastly, a social worker, 28 years old female. She says, there's so much injustice taking place in Trinidad and Tobago. Can't we have at least one court in place where judges rule with fairness and integrity and not choose to sell out, whether it is for someone they know or the government? I know some may not be able to afford taking their matters to the Privy Council, but at least they are comforted knowing that the option is there. Now, please note that this is the opinion of some of the citizens of Trinidad and Tobago, and by no means a representation of the country as a whole. However, having regard to opinions of these few people, and there being a clear consensus among them on what should be done regarding this issue at hand, it is of paramount importance now that a referendum should be mandated by the government to determine whether the people of Trinidad and Tobago wants the Caribbean Court of Justice to replace the Privy Council as their final court of appeal. The government should not, after promising participatory democracy in its 2010 general elections manifesto, ignore that this is a decision that needs to be made by the people as it is for the people. Thank you.
She gave me hope. Trinidad and Tobago, we have hope. The young people seems to be coming forward. Our last speaker is a young attorney at law, Mr. Denzel Johnson. He's the legal officer of Democracy Watch. Mr. Johnson.
Thank you. Good morning, ladies and gentlemen. All protocols observed. There has been a lot of talk of late about the need to develop Caribbean jurisprudence. But why now? And why this need when we have not moved on from 1958 in terms of regional development, when we had a great opportunity to really bring the Caribbean countries together? Since Dr. Eric Williams famously declared that 1 from 10 is naught, we have gone our separate ways and have developed our legal systems and other systems differently. Our region has not really united, and we are going in different directions. But yet we are trying to establish a common jurisprudence. We hear talk about letting go of the tail of colonialism, but yet those in power are perpetuating a plantation style of governance in which the people are managed and not consulted, to borrow the words of Dr. Jackson of the University of the West Indies. The Privy Council is by no means the most important vestige of colonialism. It is not the Privy Council that's preventing us from achieving unity. It's our thinking. Just take a look at CARICOM. Byron Blake, former Assistant Secretary General of CARICOM Secretariat, stated that leadership, political leadership, has failed the Caribbean integration process and people over the last decade. Perhaps we ought to come together first, synchronize and improve our systems, get the basics right, and I think our leaders, today's politicians, owe us a duty to bring us together. Otherwise, history will hold them responsible. We have 2 symbols of Caribbean unity, the University of the West Indies, and this too is becoming weak with our UTT and other universities in the region. And the second is the West Indies cricket team. You know, in England, there's a saying. You hear it all the time. It's used when one's sense of justice is offended. When something isn't fair or if it is just not right, they say, it's just not cricket. Well, this really isn't cricket. You can't just set up the CCJ, pick a team of jurists, bowl out the Privy Council, and put that new team to bat for justice without first consulting the people it affects. This ain't cricket, and it's just not cricket. It's about a fundamental constitutional right. So I agree that there ought to be a referendum on the issue, and not just a referendum, an informed referendum. And this is where Democracy Watch will come in to educate the people. People must know what they are giving up and what it is they are going to get in its place. The Privy Council is an important pillar of our justice system. Dr. Eric Williams recognized this and considered it necessary to keep the Privy Council as the final court of appeal when we became independent in 1962 and later in 1976 when our Constitution was enacted. Because our society is too small for the judiciary to be immune or insulated from the appearance of political interference. I say the appearance of political interference because it is an established principle of law which tells us that it is not merely of some importance, but of fundamental importance that justice should not only be done, but should be manifestly and undoubtedly seen to be done. Cases have been lost, won, and aborted on this principle alone. The justification, at least in part, for the claim that justice must be seen to be done is based on the idea that law, in a sense, is about trust. Our legal system provides us with a mechanism for resolving disputes. But if people don't trust and have confidence in the system, they will be generally dissatisfied with the judgments that are issued. Even worse, they may decide not to engage with the system at all. The CCJ needs to assure us that it is insulated from political interference. We must have trust and confidence in this proposed system. The question is, can we? All you have to do is pick up the newspaper or do a Google search to see who's attending whose cocktail parties. Think about it. Many appeals to the Privy Council from this country concern alleged infringements of constitutional rights by the state. So who will be better placed to deal with those? Can we have trust and confidence in this system when there's the perception of sweetheart deals, the perception of the political arm reaching into the judiciary? Would CARICOM states who do not have a judge represented on the CCJ respect the decisions of the court? Let us do the right thing. Let us put our houses in order, sort out our institutions which have fallen into disrepute, mend our relationships with our neighbors, and ensure that a decision to embrace the CCJ is truly made by us, the people. Thank you.
Mr. Johnson, can we get a round of applause for Mr. Johnson? Okay, I should let you know that when we were having this meeting, a certain businessman rang me and he offered to produce some soft drinks and some snacks. So while we are doing the question period, we will get it on both sides. So after the meeting, you will be able to, those of you who want to have some of that, you can have it. I must thank the businessman very much for his offer. Before we start the question time, I just want to let you know, if you did not get a booklet like this, make sure you get one so it will inform you and inform your children of some of the issues for and against. You will notice that on Sunday the 3rd of May, which I think is next Sunday, we are having at Gaston Court here at 3 p.m. Public education program on crime, corruption, and the economy. And speakers would include Mary King, myself, and some other speakers. You are invited, members of the public are invited. I want to let the CLICO policyholders know through this medium and those who are here that I'm going to have a special meeting at 1:30 p.m. next week. On that date, on next week, Sunday, the 3rd of May, in order to discuss the central bank offer and in respect of what we are doing about it. But I want to put those CLICO policyholders at ease. I do not want them to get frightened. I do not want them to get scared. Your appeal is already filed in the Privy Council. So even if the government goes like a thief in the night and abolish appeals, your appeal is before the Privy Council. But I have another announcement to make at the end of this meeting, so I would just want you to bear that in mind. What we are going to have now is that we are going to have questions, and we are going to have those questions answered by anyone on the platform here. So what I would ask you to do, you have the mic, Mr. Mikeman? You have the itinerant mic? Okay. What I would want you to do is to get up. You can identify your name if you want to identify your name, but you can tell us what the question is and we'll try and answer the question. Sorry. Make sure they think.
Good morning. Good morning.
Good morning.
Everybody seems to be very, very serious this morning. So we'll just smile a little.
I thought I was smiling, but anyway, probably when I smile, I look serious.
Just lawyer, 48 years old. I met the guy, he went up to St. Peter.
He's given us a joke, anyhow, go ahead.
Lead up to a question. Said St. Peter, I'm only 48 years old. I said, yeah. But you say you're 48 years old. But according to the records we have up here, in heaven we don't make mistakes. You see, with the hours you charge and the fees you charge, and double fees you charge at 400.
I notice you're looking at me, you know.
You're 91.
All right.
What I want to say is I had a very bad experience.
Yeah, what's the question, please?
We had a case some time ago, and the judge ruled against us, Jean Permanent. We award lawyers to Frank Solomon and Refugee Amor.
Well, I'd prefer not to call names and things. Yeah.
So we lost the case, and we have to go and employ Michael last year. We won the case final. Then another small issues came across, and we had to go and employ Sina Jairam,
I don't remember you have other people here. They want to know the question. What's the question?
We have to get two Queen's Councils to prove that we're right. And it cost us about $3 million to prove we are right. It wasn't for the Privy Council. We will have been bankrupt. So nowhere I cannot see why anyone would want to remove that Privy Council. Something going so good. Why do you want to spoil it?
Okay, thank you very much. Thank you very much.
Very good article.
Yes.
Thank you. I want to comment on this plan tremendously. I think this is exactly what we need. We need this kind of discourse and debate. I teach international relations at the university, and I have to say that our students of international relations did not know about Caribbean Court of Justice and Privy Council. They're not students of law. They did not know until we teach them. And this usually starts the second or the final year of the degree program. There might be more than 75% of this population in Trinidad and Tobago. I'm guessing. I have no real evidence of that figure, who may not be aware of either of these courts and what they do. They might have heard the terms, but they really do not
know
what this issue is about, what this debate is about. So I support the call for education, because I believe the population has to make an informed decision. I also believe that people must have a say in this process. I completely support that view of this panel here. However, I think we also need to, when we are, if we are supporting a referendum, the people must be aware of both sides. What are the merits and demerits of the Privy Council? What are the merits and demerits of the Caribbean Court of Justice? Because the reason why we are here is because it's a contentious and controversial issue, and there are two sides to the debate. The second thing we want to look at is the decided cases of the Caribbean Court of Justice. So while a lot of the decisions of the Privy Council have been presented here today, the CCJ actually have about 118 appellate jurisdictions decisions. And we need to look at that and see whether there are problems and inherent biases in those decisions. We would want to look at the issue of cost, because proponents of the CCJ actually argue that taking cases to the Privy Council are very expensive. I know some of you here, including yourself and Sir Mitchell, have actually taken cases. I would like to know, and probably a comparative study of what the cost is to the Privy Council and the cost to the CCJ, because that would be a real concern of the people of this country. Money is always a problem. And finally, Sir Mitchell, St. Vincent and the Grenadines had a referendum some time ago. I guess opponent or former opponent, Ralph Gonzalez, was at the university, and he mentioned that there was a referendum, and the people in St. Vincent and the Grenadines had voted against the CCJ in support of the Privy Council. If you can possibly elaborate on that referendum, because it's important to understand some kind of antecedent or precedent of where a referendum has actually taken place and how it proceeded. Thank you very much.
It wasn't the chairman, it was actually, the chairman said, or rather, the managing director said we were trying to create political mischief. And I understand Dr. Munilal himself as minister also made some reference to persons who are collecting money. And Mr. Munilal, was it, who said that? Yes, let me say that Mr. Munilal is telling a blatant lie. The MSJ does not and will not ever seek money from anyone. We are in solidarity with people who have problems. That's part of our philosophy of solidarity, of assisting people. People came to us. We provided the media with the evidence. And I have it here. Look at the ads put out by the HEC. The HEC ad, if I may show you, said very clearly, not my ad, right? The HDC ad said very clearly, do you think you own your own home? I went on to say that persons who are licensed to occupy or rent to occupy, you don't have a title deed, you own nothing. And he goes on to tell them you have to get a mortgage. I have a letter signed by the managing director of the HDC, and we've simply whited out the name of the person to avoid victimization, signed by the managing director, telling people that they have, quote, in bold, please note that the corporation is calling upon you to complete the completed transaction, and we hereby formally give you notice that the corporation requires you to complete the purchase of the said leasehold premises within 30 days after the service of you of this notice.
They were also asking when you all received the letter, why did you all contact them before you all?
The homeowners went into the HCC. They were told they have to go to Republic Bank or TTMF and get a mortgage to pay off the HCC, and they have 30 days within which to do so. They went to the financial institutions, and many of these persons, because of their age, means that the mortgage period will be very short, 5 years, 7 years, and therefore the mortgage payment installments monthly will be very high. And given where they work, they are unable to meet that mortgage payment and therefore could not meet the mortgage. HEC would have known about that. HEC would know what the age of persons are when they sign the rent to own or the license to occupy. So the HEC is now changing its tune. And as far as we're concerned, we have won a victory. First of all, because HEC is saying they're not going to put anybody out. So that's a victory. They now say that the first letter, which is the one I just referred to, was a mistake. And they're going to issue new letters to clarify. And they're now calling on people to say that the HEC is prepared to provide internal financing. None of that was said in the advertisement. None of that was said in the letter. So we have won a victory on behalf of the rent-to-own and license-to-occupy HEC persons. And the chairman of the HEC, the minister, and the managing director, they must stop playing games with people's lives and deal straight up with the reality. We took up an issue after persons were feeling threatened with the loss of a home, loss of their shelter, after them paying monies. The managing director says, oh, MSA is talking about people who stopped paying rent. That's not true. Persons were consistently paying rent, but they were threatened by the ads and by the HEC's letter. We have won a partial victory, and we'll continue to stand in solidarity with these persons until the HEC changes its position, which is unfair and unjust.
We have so few young people. I have been arguing that the young people